presentation of the Silver Tongue Award and the conclusion, final round of the Bushrod Moot Court Tournament. My name is Matthew Meyer. I have the privilege of being the chairperson of the Institute of Bill and Rights Law Student Division this year. And I would like to thank several of our members for making this evening possible. First, Professor Devins and Lily Nichols for their work in organizing it. Daniel Carrico for making the program. Neil Gibson for working with the catering and organizing the food. And Julie Silverbook, Tim Husbetter, and Krista Barber for the other ways that they have contributed. And I also have, before I announce the Edmund Randolph Award and give a biography of our recipient, Deputy Solicitor General Edward Needler, I have an announcement that, just to remind you that tomorrow the Institute of Bill of Rights Law is co-sponsoring a conference with the William & Mary Law Review. And there are approximately a dozen professors coming to present papers and give a talk. I believe it starts at 1:30 tomorrow. It also runs from around 9:30 Saturday morning to noon. And I encourage you to be there because 2 U's are already coming. There's Chris Yu from the University of Pennsylvania and John Yu, you may be familiar with from Berkeley. And so, pun intended, I hope you will be there. We have so the other professors, of course, representing many of the top 15 schools. And now I have the privilege of discussing the Edmund Randolph Award. The award was created in 2008 in remembrance of Edmund Randolph, who was the nation's first Attorney General. He was a graduate of William & Mary, worked with his father in a career in law, was a delegate to the Virginia House of Delegates, was a governor at the time of the Constitutional Convention. He was a delegate to the Annapolis Convention, which was a precursor to the Constitutional Convention. And then, of course, he presented the Virginia Plan at the Constitutional Convention, which was really the, compared with the New Jersey Plan, it was formed the backbone of the draft of the Constitution. Previous recipients have been Seth Waxman, Paul Clement in 2009, and Beth Brinkman last year. And we're pleased this year that Mr. Needler has agreed to accept the award. He's a senior career, the senior career Deputy Solicitor General in the Office of Solicitor General, which is the office of the Department of Justice that represents the U.S. government before the Supreme Court. In 2009, he served as acting Solicitor General before Elena Kagan's confirmation. He has supervisory responsibilities over a number of the cases that the U.S. presents to the Supreme Court, including constitutional and other challenges to agency programs, immigration law, federal benefits, natural resources, Native American law, and some international law issues. He's also responsible for assisting the Solicitor General in deciding which cases and the lower courts to appeal. Mr. Needler is one of only 8 people to have ever argued more than 100 cases before the Supreme Court. He told me earlier today the current count is 111. He has argued among those many controversial cases, including Ricci v. DeStefano, Wyatt v. Levin, INS v. St. Cyr, Legal Services v. Velasquez, and Lujan v. Defenders of Wildlife. He has also filed or participated in the drafting of more than 60 briefs, even when he wasn't arguing the case before the Supreme Court. He's represented the U.S. government before the Circuit Courts of Appeals approximately 10 times, and he has represented the government before the district courts, including most recently the argument to the district court in Arizona over the immigration law. Before joining the Solicitor General's office, Mr. Needler served for 4 years in the Justice Department's Office of Legal Counsel, which was at the time headed by now Justice Scalia. He clerked for Judge James R. Browning in the Ninth Circuit Court of Appeals. He is a 1967 graduate of Lehigh University and a 1974 graduate of the University of Virginia Law School. Please join me in welcoming Mr. Needler. Mr. Needler, on behalf of the Institute of Bill of Rights Law and the Moot Court team, we are pleased to present you with the 2011 Edmund Randolph Award, popularly known as the Silver Tongue Award. Thank you very much. Thank you. And then we also, it's tradition, we have a plaster tongue. And Mr. Niebler needs to add his signature to the likes of Seth Waxman, Paul Clement, and Beth Brinkman. And I don't know, Martin, you want me to hold it?
How delicate is it? I don't know. This is quite a list to me. Wow.
All right. And I will leave it for display in case anyone's interested. We have a glass case that it goes in Professor Denver's office. All right. And now at this time, Mr. Niebler is going to give some remarks about Solicitor General's role.
Thank you very much. This is a great honor, and it's a great privilege to be here, and it's wonderful to have my name added to this list. I know there's advocates on there. I hadn't seen this sort of list before, but in this forum. But that too is wonderful. But it's a real privilege to be included with that, with those people who are among the great current advocates in the court. And it's also particularly meaningful to me to receive an award named for Edmund Randolph, First Attorney General. I've spent 35 years in the Department of Justice, and he started out, and I think it was he and a clerk were the Department of Justice, or the equivalent of that was the role. Now we have, I don't know, something like 100,000 employees with the FBI and ATF and marshals, and it's a huge department. But the organization, the philosophy, the whole approach to what being Attorney General means started with Edmund Randolph. And I remember one of my very obscure specialties when you work for the government in a generalist position. You never know what's going to come your way. One of the things that I've worked on every 10 years are challenges to the census and the way the census is conducted, which for the first 180 years of our country, no one ever sued about the census, but starting in 1980 or 1990, we got suits every decade. And so the statutory formula for apportioning representatives, the statutes governing how you count people, which sounds like a simple concept, but trust me, it's not a simple concept. What statistical sampling do you use, that sort of thing. But I had occasion to go back and look at the early census statutes. The first veto exercised by a president, if I'm remembering this correctly, was the first census, or the first apportionment statute. And I read the account of the cabinet meeting with Edmund Randolph and Jefferson, and everybody had different views, and they were all speaking as if it was very high-minded, but you sort of had the sense that their point of view on the cabinet depended on which state they were coming from and which state might come out better in the apportionment. But it was what really came through is the challenge, the practical challenge of setting up a government, and just the recitation of his career before he became Attorney General. Those were times when people who assumed those roles had public lives and involvement in all sorts of walks of life. That they brought experience and wisdom to what they're doing. We live in a time of specialization now, where it's very difficult for any one person to have the breadth of knowledge and experience that people from our founding generation had. And I think it's a challenge to all of us. It's a challenge to me in the government. It will be a challenge to you in your professions to how do you accommodate being a specialist, and how do you accommodate being a generalist? How do you accommodate being a public figure? Because lawyers are necessarily, as officers of the court, there's an element of public service and public figure in whatever you do, even when you're representing private clients. And when you work for the government, as I do, there's special responsibilities that come from that, and also special privileges and special rewards that come from working for the government. But I do think, and as I say this, I'm challenging myself, to think more broadly and think in the nature of the public calling that the members of our founding generation, and you're so close to the roots in this state and at this school, to bear in mind and to call back on that as you go forward. And I know I don't do enough reflection, although in the corridor that I am in at the Department of Justice has the portraits of all, not all, but a number of the Attorney General through history, and some of them go way back, some of them are more recent, but it is a reminder when I walk down the hall of all who have gone before and how they have built the great institution of the Department of Justice. We didn't even actually become a department until 1870, so in those early years it was the Attorney General and a couple of assistants and the U.S. attorneys, or what were then called district attorneys, out in the field. I think for a long period of time they weren't even supervised by the Attorney General. They were either active on their own or they were supervised by the Department of Treasury, and the government was very diffuse. And now we have a more centralized government, a more centralized administration of justice. And it is a large responsibility and a very important calling in the administration of justice at the Justice Department. And I have to say, and I said this earlier today, I would encourage you all to think of some sort of public service at some point in your life, because in my experience at the Justice Department, for example, it has been a source of great camaraderie, great support, and I tell people when they, what's it like? And I say that people are trying to do the right thing and coming to the right conclusion and to help each other, and that it's true in the government, it's true elsewhere, but it's particularly true in the government. There are a couple things that I wanted to just mention about advocacy, and we're about to see a moot court here. But when I think about moot courts, I think about the sometimes unpleasant experience of going through the practice moot courts that I do before we have oral arguments. And for the first 10 years I was in the Solicitor General's office, believe it or not, we did not do moot courts before we did arguments in the Supreme Court. Of course, the court was a very different court at that time. The justices were not active questioners. But the preparation for the argument was a lonely experience. And if you're someone who is somewhat shy or introverted or something like I was, particularly back then, you say, geez, I don't know whether I should ask anybody this question. So we did a lot of time preparing by ourselves and asking the deputy responsible for the case for advice. But it was a very lonely experience, frankly. And when Ken Starr became Solicitor General in, was that 1989, I guess, he insisted that we each do 2 moot courts before we had an oral argument in the Supreme Court. And there was a lot of resistance in our office. I think that the people thought they were pretty good at what they did, and we don't need to do that. But I think there was another piece of it, it's probably true in a lot of walks of life. You'll see lawyers who have some bravado, masking insecurity. And I think a lot of us were reluctant to stand up before our colleagues. We asked tough questions, and we worried about our performance. And I can tell you that it was the best thing that ever happened to our office, which was to go through those moot courts. They perform the obvious function of preparing us for argument, because you get an array of questions and tough questions, and people are not supposed to be unforgiving in the questions and really probe you and come up with questions out of left field so you're prepared. But the other part of it that I didn't appreciate was it's become the ethic of the office to rebuild you after the moot court. If you go to a moot court and you ask somebody tough questions, it's your responsibility afterward to build them up and give them suggestions. Okay, you didn't like my answer, what would your answer to that be? And the other thing it did is it got people invested in each other's cases. So as you were preparing, you didn't feel quite as lonely. And you felt like if somebody came to your moot court, you could talk to them afterward about it, and people would follow up with you. And then when you went into court, you felt like, you know, sometimes the colleagues would be in the courtroom watching your argument, but even if they weren't, you sort of had the sense that you were a member of a team, and you weren't just a single lawyer. Now, you know, you all will go out and practice in different ways, and some of you may be on your own, and some of you may be in a group practice or an office, but I encourage you to think about not doing it alone. There is an important way in which a lawyer is alone. You are ultimately responsible for what you do, for what you say, for what you sign, for what you write. The law has to be that way. The practice of the profession has to be that way. You have to take personal responsibility for what you do. That includes being thorough. It includes being candid. It includes being prepared. It also includes being yourself in terms of your presentations to the court. But that doesn't mean that you have to get to that point by yourself. The ultimate things you do, standing up in court or signing a brief, you're responsible. But I encourage you to draw on your colleagues, wherever you are, for advice, for support, and to reciprocate the other way. And that also includes not just the members of your particular office, but I think it also includes the members of the bar more generally. Because I think it's particularly in these times where there's a lot of partisan divide and competition in the profession, I think it's very important to maintain the sense of civility, not only with the people on our own team, but a sense of civility with people on the other side of cases. It may be with them the next time, but it's very important to have a sense of common calling and shared calling in what we're doing, because it is an honorable profession, and I think it's important to remind ourselves of that, because we can get so caught up in winning the particular case. So that is really a transformative thing that happened in our office. I encourage you to think about. And as I said earlier today as well, I would really encourage you to soak up everything you can about the law while you're in law school. I tried to do that, and I fell short in a lot of ways, but I think in particular, one of the things that you will often not have an opportunity to do when you're in practice is to study legal history and constitutional history and the sort of broader context in which you're practicing law, because you're likely to become specialized or you're likely not to have the time. And so I think it's very important in being prepared for the law and also to be frankly a representative of the profession and the community, whatever your community may be, to be conversant in the basic principles of our constitutional founding and the basic principles of liberty and separation of powers under which we work. And I think if we have a sense of that history and that foundation on which we stand, an important foundation on which we stand, I think it can give us a sense of confidence in what we're doing, a sense of gratitude for what we're doing, and a sense of perspective. We're living in a world now where there are huge changes happening in the Middle East, and it's cries for liberty, much like the cries for liberty that caused the founding of our country. And I think it is a moment in time when we can recall back to our own founding principles and how we've tried to become a more perfect union over the 2 centuries or more than 2 centuries since then. So I thank you for this award and thank you for the opportunity to come to this place and to reflect upon the first boss of the place where I've devoted my legal career. I wish you all well, and I hope to have a chance to meet you individually after this evening. Thank you again.
The judges are now dismissed to the roving room to be robed, and Kyle Elliott is going to come and give thanks to the Moot Court team and a description of the problem.
Kyle Elliott, and I am the Bushrod Justice for the Moot Court team. Our responsibilities are to administer this Bushrod tournament. For some of you that know, this has been going on for, I guess, the 5th week now. Congratulations on making it to the finals. I'd just like to give a few thanks to the judges, competitors, and everyone who made the tournament possible over the last few weeks. I'd also like to thank the justices serving on the final panel this evening, Mr. Needler, Professor Zick, Brad Bartels, Mark Connolly, Rebecca Sandler, Davis Walsh, and Melissa Kessler. I'd also like to give additional thanks to Mark Connolly for writing the problem this year. He did an excellent job, and I think it's been a good problem for everyone and hopefully enjoyable for those who competed. And Chris Jackson for being for his tireless work and effort as the Associate Bushrod Justice. He really helped me out a lot. I see a lot of familiar faces and competitors, so I know many of you are very familiar with this problem. But for those of you who are not, the problem takes place in the fictional state of With. Pursuant to an act of the legislature, a specialty license plate was issued that read With is a pro-life state. The class of petitioners, through a different mechanism, applied for a specialty license plate that read the private citizens of With for choice. The Department of Motor Vehicles, or the With Motor Vehicles Commission, denied petitioners' application, and petitioners have filed suit alleging that the With Motor Vehicle Commission engaged in viewpoint discrimination based on their license plate. The competitors are being asked to determine what kind of speech this is in this case, whether it's governmental, purely private, or some kind of hybrid of the two. Furthermore, they're asked to engage in a forum analysis to determine whether this is some kind of limited public forum or no forum at all, which determines what kind of scrutiny under the First Amendment the judges will apply. So without further ado, I welcome Jess Delaney representing the petitioner and Tessa Vincent representing the respondent.
All rise. Oyez, oyez, oyez. All those having business before this, the Supreme Court of the United States, are admonished to draw near and give their attention. The Supreme Court of the United States is now in session. Justices Connolly, Sandler, Zick, Bartels, Kessler, and Walsh, and the Chief Justice, Needler, are presiding. The first case on the calendar is Holloway against With Motor Vehicle Commission.
Seated. We'll hear argument next in Holloway and Planned Parenthood With versus With Motor Vehicle Commission. Counsel for petitioner.
I'd like to spin this around. Mr. Chief Justice, and may it please the court, I am Jessica Delaney, and I will be arguing on behalf of the petitioner, Joan Holloway, and the Planned Parenthood of With Incorporated. May I reserve 1.5 minutes for rebuttal?
You may.
Thank you. Petitioner respectfully requests that this court adopt the Rose 4-point test for determining private expression. Furthermore, upon applying this test, this court will find that With Specialty License Plate Program has created a limited forum for private expression, and within said forum, petitioner is subject to unconstitutional viewpoint discrimination. Petitioner thus requests that this court enjoin With from all activities pursuant to statute 1067. The Rose 4-point test was adopted in 4 of the circuit courts to determine whether or not specialty license plates constituted private expression or
But Counselor, Rose was adopted before our test in Johans, correct?
Yes, Your Honor.
So why is it Johans, which is our binding precedent, appropriate here?
Because, Your Honor, even within Johans, the Supreme Court determined that in cases in which speech could be attributable to an individual citizen, that their test for government speech is not necessarily applicable. In Johans, they looked at both the central purpose of the program as well as the editorial control exercised by the government. This court specifically disclaimed, however, the applicability of Johans in cases where individual citizens could be seen as advocating the individual private
Do
expression.
you think there's any part of this program that is government at all? I mean, do you see any distinction between the state identified specialty plates that with is a pro-life state and the other parts of the program? Is there any difference between those?
Your Honor, there is a definite connection to government speech in this case. License plates are, of course, public property, are government property, and additionally, the with is a pro-life state was put forth through the legislature. However, by applying the Rose 4-point test, it's a way to determine whether or not the actual speech itself is solely government speech or private expression. Unlike Johan, this is not a case of a government program. The only program here is the actual license plates, which is another reason why this court should adopt the Rose test as opposed.
Counsel, can I take you back for a second? Did you say that under Rose we have to find it's either private speech or public speech, not a mixed speech?
Your Honor, in 3 of the 4 circuits, it was found to be a situation of mixed speech. However, even if this court were to find a situation of mixed speech that calls into question First Amendment rights of individual citizens.
Are you arguing that this is purely private speech, or are you arguing that this is mixed speech?
Your Honor, this could be seen as a situation of purely private speech. However, under both Johans and the Rose 4-point test, there is an element of editorial control. Petitioner concedes that WITH does exercise a significant amount of editorial control in their specialty license plate program.
Could you tell us how this is purely private speech?
Because, Your Honor, even editorial control is not completely governmental in nature. Under none of the specialty license plate programs, none of the actual license plate, the government creates the message itself.
But who exercises the final authority?
The final authority for...
The license plate. Isn't it the government? So
Your
don't
Honor,
they have editorial control?
the government is the one who actually creates and distributes the license plate. However, it's the individual citizens who must purchase it. The government has no ability to force individual motorists to put license plates on their
Right,
car.
but they have control over the message that goes on the license plate. So they have ultimate editorial control.
They have ultimate veto power, Your Honor, but the government has not designed the license plate. Marshall Friends for Life was the nonprofit organization which designed the license plate for the WITH as a pro-life state.
Why does it matter who designed it? Isn't the government responsible if the government is issuing in the Zoom cases I recall, there were private memorials that would be placed in the park. The court treated that as government speech, not private.
Yes, Your Honor, you're correct. It's merely pointing out the fact that even editorial control, which is the strongest factor in this case for government speech, shares some elements of private expression. Additionally, the case is distinguishable from Suman in that that case found largely that the individual monuments constitute government speech because of their permanent nature on government property. Although these messages are printed on government property, the license plates, that property is then put on private individuals'
But Counselor,
cars.
the message here was dictated by the WITH General Assembly. It was said that you will authorize a plate that says WITH is a pro-life state. So it's not merely editorial control here, and it wasn't just Marshall Friends for Life coming up with this idea. The actual message was dictated by the government, and that seems to me to be clear government speech.
And Your Honor, that's why petitioner concedes that that is the weakest point for a finding of private expression. However, under the Rose 4-point test, there are still 3 more factors in determining private expression. The first is, of course, the central purpose of the program. Looking at it objectively, WITH has created a limited forum for private expression by creating these specialty license
But
plates.
counsel, is that really a purpose? Isn't the purpose here to fund pro-life groups?
Well, Your Honor, you have to look at the specialty license plate program as a whole. If we look merely at the WITH as a pro-life license plate, it's precluding a finding for the forum as a whole. The government has created a way for individuals to show their support of pro-life.
Well then, let me change my question a little bit. Even if we include the entire specialty license plate, it's still the purpose is to fund those groups which the license plates promote. In my home state of Virginia, if I have a William & Mary license plate, William & Mary is getting the money, and that's the purpose of the program, is it not?
Yes, Your Honor, which is actually pointing more toward private expression. The government here is receiving no revenue from the specialty license plate program. It's not even subsidizing the program. Instead, the money used to go toward the specialty license plates comes from the individual motorists who pay an extra fee to receive those license plates. Additionally, they're displaying these license plates on their private vehicles. This is clearly a case in which the individual motorists have the opportunity to express their private speech, their private expression, with regard to the different organizations and speech on the license plate.
If the state required all license plates to say with is a pro-life state, would that be government speech?
Your Honor, it would be government speech, but would be a case of compelled speech, which the government cannot do. The similar case in Woolley v. Maynard established the fact that the license plate, although in that case was government speech and government property, had an element of private expression. That's why the compelled speech was a serious issue for this court.
So why can't you look at the situation of you can either request one of these plates or not as the same thing of whether you can cover up live free or die on your license plate? There's an element of choice, but you're choosing whether to be the spokesperson for the government or not when you sign up for it.
Yes, Your Honor, but within a limited public forum, the government cannot put its own speech forth to the detriment of an opposing viewpoint. That's what's happening in this case.
Is that true? I mean, what case supports that? I understand that if the government has a limited public forum, it can't favor one private form of expression. But why can't you have a situation where the government puts its own speech out there, as it does with as a pro-life state, and then it has this other opportunity for people to come up with their own specialty plates if they want to express their own view?
Well, Your Honor, were that the case, that would be acceptable. The government may fund its own activities and need not fund alternative ones. However, as we've seen in a number of government programs, including Legal Services v. Velasquez, or even Rosenberger, the government cannot put itself into the forum as a private speaker and then preclude other viewpoints merely because they're contrary. In this case, petitioner's specialty license plate was denied based upon a viewpoint which was contrary to that of the government.
Counsel, aren't you jumping the gun? You're going straight to form analysis, and we haven't even decided if this is government speech, private speech, or what it is. If we find this to be government speech, the government can say whatever it wants. Am I wrong?
You're right, Your Honor. If the entire specialty license plate program is found to be a case of government speech, the government is under no obligation to pay for things which don't comport with its speech. However, that takes us back to both Johans and to the Rose 4-point test, with the final factor of who the speech is actually attributable to.
Counselor, on that, I'm happy you brought up Rosenberger. Didn't we say in Rosenberger that when the government elicits private individuals to convey the government's viewpoint, that the speech remains government speech? That seems to be exactly what's happening here. The General Assembly said, you're going to have a license plate that says this, you're going to let people purchase it and donate money, and that's what happened.
Well, Your Honor, there's a difference between eliciting volunteers and having individual citizens using a program to promote their own private expression. These individual
But
members...
Counselor, here, the General Assembly Act said someone should come forward and put in an application for this license plate, and when it comes in, you will approve it. That seems to me to be directly eliciting a private individual to display the government message.
But, Your Honor, the speech is actually associated not with the government, but with the person whose car is actually displaying that message.
Why is that necessarily true here? With respect to attribution, the message is with is a pro-life state. Is there any reason to think that members of the public will be confused about whose message that is?
There absolutely is, Your Honor, because of the fact that we don't have this one license plate. With legislature has also passed acts saying Bronze Star recipient, they have one for a football league, they have another license plate regarding bicycling enthusiasm. None of those are directly attributable to the government, yet they were created in the exact same manner.
But those are, what happens if we view the license plate, the width is a pro-life state as government speech? I mean, after all, it's describing what the state is, not what it doesn't say, I am a pro-life driver. It says with is a pro-life state. That sounds like something the state says. So how should we think about this case if that part of the program is government speech, but the other specialty license plates in which the private group comes forward and proposes a specialty plate, if we thought that that's private, how should we think about the case?
Well, Your Honor, in that case, it would be a situation of mixed speech, which would lead to forum analysis. In this case, what we have is a limited public forum for private expression. The government has deliberately created a way in which multiple different people can espouse different viewpoints by putting different specialty license plates onto their car. In such a forum, the government may only regulate speech based upon viewpoint neutrality and a reasonableness factor. In this case, the government has already created a specialty license plate with regard to the abortion debate.
Isn't it possible to characterize the two different statutory schemes as two different forms?
Your Honor, the form here is the specialty license plate itself. Individual constituents don't know the difference between what has actually been passed or what has not, and the way it's seen by the public is the way it's actually put on the car. The reason that government speech is not subject to First Amendment scrutiny is because of the clear electoral accountability.
But Counsel, to dovetail off that question, can you give us any cases where we determined whether something, what the forum is based on how the public perceives it rather than what the government's action was?
Well, Your Honor, even in Johans, which was established as government speech, this government said that if a reasonable person would attribute speech to an individual citizen, then we have to look at the First Amendment. In this case, in this court even, Willie v. Maynard established that license plates are attributable to the person on whose car they are. Additionally, in Perry v. McDonald in the circuit courts, it was found with very little discussion that a vanity license plate is an example of private expression. The license plates, then are being seen as examples of private expression that individual citizens are putting forth in this limited public forum.
In the Sumim case, the court, we said that a public park could be a traditional public forum for one purpose and not a public forum at all, but a place for government speech in another. So why couldn't we do the same thing here?
Well, Your Honor, one of the main points in Sumim was the fact that there's limited government land. The memorials become government speech because, number one, they are seen by individuals as examples of government speech, and additionally because there is no way for the government to allow unlimited discourse, or even significant discourse.
Counsel, would you like to reserve the, I see you have 1 minute left, would you like to reserve the balance for the vote? Oh, she has, I'm sorry. Sorry about that.
Thank you, Your Honor.
You'd think I'd know the procedures of my own court.
Thank you. For the reasons mentioned, that therefore this petitioner respectfully requests that this court adopt the Rose 4-point test, and under it find that WITH has created a limited public forum for private expression, and that within said forum, petitioner was unconstitutionally subject to viewpoint discrimination. Thus, petitioner requests that this court enjoin WITH from all activities pursuant to statute 1067.
Thank you, Counsel.
Honorable Chief Justice, and may it please the Court. My name is Tessa Vinson, and I arise today on behalf of the respondent, the State of WITH Motor Vehicle Commission, and the State of WITH Department of Social Services. Respondents respectfully request today that the Court uphold the decision of the 14th Circuit Court of Appeals and find that the WITH Act is constitutional. Respondents will argue that the speech on this license plate constitutes government speech, and for that reason should not be subjected to First Amendment scrutiny. In addition, respondents argue that if the court today finds that this is a situation of hybrid speech, the WITH Act can still be found constitutional. First, the standard that should be applied today was the standard set out by this court in the Johans case. This court held that speech could be classified as government speech as long as the government set the overall tone of the message and maintained editorial control over every word that was going to be disseminated.
But isn't the forum for specialty license plates fundamentally different than the forum in Johans? And
Yeah.
here, nobody's being forced to pay for anything, and the entire cost of the specialty plates are borne by the individuals that buy them.
Yes, Your Honor. Johans was a forum for compelled speech, and that was the fact pattern that was presented. However, the way in which the decision was handed down and the way in which the court handled the analysis suggests that this test could be applied in situations where compelled speech wasn't the issue or a forum was differentiated from that in the Johans case. But Counselor, our circuit courts, who are very well aware of our decision in Johans, found it to be unworkable in the specialty license plate scenario. Why should we cut against this wisdom? Your Honor, the circuit courts have adopted, most of them have adopted the four-factor test from the Fourth Circuit. However, the Sixth Circuit did apply the Johans test and found it to be workable in a situation very similar to this one. And they found that the license plate Choose Life, to the exclusion of a pro-choice license plate, was also constitutional and it constituted government speech. And that the enlistment of a private individual or entity in disseminating that message did not strip the government of its right to be government speech.
But Counsel, it seems to be that you're hanging your hat on the Sixth Circuit. Why is the Sixth Circuit so much more right than the other four?
Your Honor, respondents would argue that the Sixth Circuit recognized that within the Johans test doesn't completely exclude the private expression component that the other circuits have found a problem with the Johans test. And that is because within the Johans test, the first prong could have a situation where a private entity would establish the message and develop the message, and the government would approve that message and send it out. And so in that particular situation, you could still have private expression with government editorial control. And
But that's different from this, preparing something and giving it to the government, and then the government adopts it and sends it out. The government is ultimately responsible for what goes out. But in this situation, let's put to one side who developed the message. There is in every instance an important element of private choice. That license plate does not get on the automobile unless the individual chooses to purchase the plate. Right?
Yes, Your Honor, and that's why the respondent isn't ignoring the fact that there is an important role for the individual in this particular case. However, this court has held that the individual can play a role in disseminating that message without the government losing its right to claim it as government speech. And as a component of that third and fourth factor of the Fourth Circuit test, which you indicated, the respondents contend that there can still be an identification of the government as the literal speaker, even though that plate is on an individual car. Because in this particular instance, the forum would be limited to the license plate in itself. And that license plate bears a government message that is directly related to the state in the fact that the statement says, "With is a pro-life state." And that statement is imposed on government property.
Is it your argument that all of the specialty license plate messages, including the ones under the general statute, are government speech?
No, Your Honor. It's in particular this case. In other situations, such as bicycle enthusiasts, there are elements that are private that are not indicated in this particular situation. For instance, those messages were created by private individuals or private organizations, and that is private speech on that license plate.
Then it strikes me that you run into the problem that you may have created a limited public forum.
Yes, Your Honor, and that is why respondents argue that even if it's hybrid speech and in a limited public forum, their act can still be considered constitutional.
But you can't discriminate based on viewpoint in that kind of forum. It strikes me that there's where your problem lies.
Your Honor, respondents have two main reasons as to why that restriction is considered viewpoint neutral. And the first is that the WIT Act created a government program in the sense that it created a mechanism to raise money and raise funds to support public policy, and it distributed those funds through a government organization. And this court held in Rust v. Sullivan that when a government program is created, the government has the ability to fund one program to the exclusion of funding an alternative program that would address that matter in a different way.
If we didn't have the part of the program that WIT is a pro-life state, and we were just focusing on the organizational part of it, or maybe let's just focus on the organizational ones where the organizations come forward. You would concede, if we thought of that as the relevant forum, you would concede that that's a private forum of some sort, either limited public forum or limited forum.
Yes, Your Honor.
So in that situation, can the commission deny the license plate that the petitioners here wanted to have?
That's actually the second point of the respondent's argument, is that the restriction here was not based on the viewpoint that was espoused by the petitioner's plate. When the commissioner made his decision to deny the application, he was doing so within the discretion that he was given by the Specialty License Plate Act, which said that he could address community standards when determining whether or not to
But didn't he just look at what the WIT legislature said?
Yes, Your Honor. However, that using the WIT legislature as a barometer for community standards is a reasonable barometer for what the community would believe to be acceptable in that particular form or in that.
If another group, if a pro-life group wanted to come forward for a specialty license plate, not the one the state has provided, but their own, and the commission looked at community standards and said that seems to mesh with our community standards better, and they granted that, would that be viewpoint discrimination then?
No, Your Honor, because if they use the legislature as a barometer for what the community standard is.
Well, but the community standard seems like it's viewpoint discrimination. I mean, even if the community wants to discriminate on the basis of viewpoint, that doesn't mean the First Amendment would allow.
No, Your Honor, and that what the respondent is arguing is that when the legislature made their decision, they had both sides had equal access to that forum, and that's where that expression could take place. And that
But the legislature makes the decision, and then you look to the legislature for community standards. I mean, don't you see the problem here?
No, Your Honor, because in that particular situation, if the commissioner is looking to the legislature itself is held accountable to the citizens. And if the citizens felt that the legislature had made a wrong or poor decision, then they could vote those legislators out of office.
But counsel, isn't the point of the First Amendment in many ways to protect the minority over the majority? And if we just focus on electoral accountability, we're just allowing the majority viewpoint to win the day in and day out?
Yes, Your Honor, the point of the First Amendment is to allow minorities to be able to express themselves, even if it is against what the majority is espousing. However, there are limitations, there are situations in which limitations have been held constitutional.
But Counselor, back to the Chief Justice's question here, didn't we find in Ward that government cannot deny a viewpoint merely in some type of public forum merely because it does not agree with the viewpoint? Here it seems just to be saying that the commission said, well, the legislature doesn't agree with this viewpoint, so we should not allow it.
Yes, Your Honor, and that is why the respondents have also argued that if, in fact, this is found to be viewpoint discrimination, it is a situation in which such discrimination can be found to be permissible, as is held in Sons of Confederate Veterans, that the presumed unconstitutionality of such restrictions can be rebutted as long as they demonstrate a compelling government interest, and that this was the least
What's the
restrictive
compelling government interest here?
There are two, Your Honor. The first being the ability of the government to be able to use its own property to disseminate its policy message and to create programs to fund its own policies and its policy initiatives. And the second being, is this court held in Rosenberger to clearly articulate what its policy is on a particular issue within a particular arena. And
So are you suggesting we apply strict scrutiny?
yes, Your Honor.
So how is this narrowly tailored?
It is narrowly tailored.
And the least restrictive means?
It is narrowly tailored, Your Honor, because in this particular instance, the interest of the government is in using this forum to clarify and acknowledge what its policy is and to raise those funds. And this is narrowly tailored because it is merely restricting access to a piece of government property, which this court has held the government has the right.
Counsel, you said earlier in your argument that there are situations where the public is going to have access to that property, and now you're telling us that the issue is that the public doesn't have access, that the government has to control the message. But earlier, if we were looking at the second statute, you said that this was a situation where private groups could have access. So now we have if you're in the majority, you win. If you're in the minority, you lose situation. Or do you dispute that?
Yes, Your Honor. The contention that the respondent is making is that the private citizens do have access to the forum through the fact that it is a specialty license plate forum. However, in this particular situation, there is an application process to be allowed access to that forum.
So, Counselor, what you're saying is that anyone can apply to be in the forum, but once the government has spoken in that forum on a specific issue, no other viewpoint can come in. So if it doesn't agree with the government's viewpoint, that seems to me to cut against exactly what the First Amendment was established to prevent.
No, Your Honor, it's not if the message expressly disagrees with the government's viewpoint. It's the sense that in this particular situation, it was not denied because of the viewpoint. It was denied based on a community standard. And in that situation, that was based on the legislature, and that was a valid measure of what the community standard is. And so it's not the fact that the message itself disagrees, it's that the community standard that the commissioner read into allowed him to make that decision.
Counsel, to return to your compelling interest or least restricted means argument, you're discussing this as in the government has to have this form available for its speech, correct?
Yes, Your Honor.
If going back to the license plate hypothetical, if I have a license plate that has my alma mater William & Mary on it, does that mean the government is speaking pro-William & Mary?
No, Your Honor, not necessarily. It merely means that the government has allowed the William & Mary emblem, I suppose it would be in this case, to be on that license plate. And then in that situation, it would be a mixture of government and private speech.
So I'm having a hard time differentiating between your arguments that the government must have access to this forum to disseminate its message, yet at the same time, it's not always government speech.
Yes, Your Honor, the respondents are arguing that the government has access and has rights to use that forum for its own expression just as much as a private citizen would have those rights to use it. However, in certain situations when the government feels that it needs to clarify its message or keep its message from being garbled with other messages, it has the right to impose such viewpoint restrictions.
So if the government thought that William and Mary was a bad thing, they could say no to the license plate, even though another university might be able to use that forum?
Not necessarily, Your Honor. That would be another situation in which the license plate would be denied and have to be on community standards. And if the legislature or some other community standard arose that would allow for dismissal of that license plate, then perhaps the application could be denied, but it could not be denied merely on the basis that the government itself
You
disagrees.
keep mentioning community standards, but I'm not still sure I know what that means. So let's change the license plate to something like WIT is a pro-hetero state. And some organization comes forward and says, we want a license plate that says WIT is a pro-homo state. Can that be constitutionally denied to the organizational group on the reason you've given us? Under the First Amendment, never mind the equal protection clause.
No, Your Honor, we wouldn't argue that that could be constitutionally denied. It would depend on many other factors, including if another license plate to the contrary was allowed into a forum, what the commissioner was using in his argument for community
It
standards.
was using the same thing. The legislature has determined previously that pro-hetero is the state's position, and that's your community standard.
That is one component of the community standard, yes, Your Honor, and when he was taking into consideration...
Isn't that the only component, though?
Not necessarily, Your Honor, and the...
What else did he look to? In this case, he looked to the legislature.
Yes, Your Honor, he looked to the legislature, and he also looked to information that was in the application, for instance, the number of signatories that had
And they
signed up.
satisfied all of that information.
Yes, Your Honor, they did. However, he took a balancing between the legislature and the number of applications that he had for that application. And in determining that...
They had more applications than necessary.
Yes, Your Honor, they did, but that does not necessarily mean that that would satisfy the community standard in the sense of the legislature is more traditionally and more reasonably...
Well, but I'm not buying
considered
that. So you set a limit, or you set a minimum number, and they exceeded that. So isn't that your argument for a community? There's enough people in the community. In fact, there's more than we require as a minimum.
Yes, Your Honor, but the...
So how's that balanced, though?
The respondent, when the commissioner made that decision, he took into consideration the weight of the legislature as a historical embodiment of what the community... I see my time is up. May I briefly conclude? He took into consideration the weight of the fact that the legislature is traditionally an emblem of what the community stands for, and that's why he gave more weight to that particular instance. And it is for that reason that respondents argue the WIT Act is constitutional. Thank you.
Thank you.
Your Honors, the respondent has predicated a large portion of her argument upon the fact that this is a government program.
Counselor, why is this a single act that deserves a classification of mixed speech? It seems like there's actually two acts going on here. The first is that a private group already received their First Amendment protection by offering their license plate to the state, and the state rejected it, and they said, with their final authority of approval, and said, no, we reject your proposal for your private license plate. So how does the First Amendment apply here?
Because, Your Honor, this court has never held that in a case in which there are some elements of private expression that the government may regulate speech and may discriminate based upon viewpoint. Because of the fact that petitioners, by creating the WIT as a pro-life license plate, the WIT legislature already created a content within this public forum.
Suppose we don't agree with you on that's government speech, and the relevant forum is the other private specialty plates. And suppose we also agree with you that there was unconstitutional viewpoint discrimination. What is the right remedy there? Is the whole statute unconstitutional? What are you asking us to do?
Your Honor, petitioner is requesting that this court enjoin WIT from all activities pursuant to the WIT as a pro-life license plate, effectively rendering the entire content out of this forum.
But I guess I don't understand why that's the... I'm sorry, I see your time is up. Thank you.
Thank you.
The case is submitted. I guess there are no more arguments today. Thank you.